Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda, and this is our 16th presentation in this series on the First Amendment to provide a little something extra for my students who I'm teaching remotely and to help all of us on our path to justice by learning more about the Constitution. Now let's get right to it. We've been talking about some basic rules related to the First Amendment and speech rights. And recently, we've been looking at how those rules may become more complicated or perhaps more twisted by the court. Remember, we said that pure speech is protected from content regulation by the government unless the government can satisfy a very high exacting level of review called strict scrutiny. We said that pure conduct is outside the reach of the First Amendment. Pure conduct is not protected as speech under the First Amendment. And we also said that while generally pure speech is protected unless from content regulation, unless government can satisfy the most exacting level of review, there is some speech that government has more leeway to regulate. That is speech that is included in the unprotected categories. We complicated it a little more. And we said pure speech protected from content regulation, some speech in an unprotected category, but some things fall in the middle, especially when government is able to show that it really wasn't regulating the content of the speech. Government may be able to succeed in arguing that it was a reasonable time, place, and manner regulation, not really about suppressing speech. So we looked at several categories of speech that fall in this middle. Now today, we're going to examine another category that may fall in the middle. We said pure speech, then we said pure conduct is outside the reach. Well, what about speech that is a combination of speech and conduct? Where does it fall? Is it pure speech? Is it pure conduct? Or is it somewhere in the middle? If it's somewhere in the middle, we have a whole nother test that we use. But first, what I want to do is I want to give you 3 different scenarios. And what I want you to think about, is this pure speech entitled to full protection, or is it pure conduct outside the reach, or is it something in the middle? So this is I'm going to give you 3 scenarios, and here's the first one, scenario 1. So it was during the time when we had a mandatory military draft, and individuals, men, who were required to sign up through the selective service system would be given a draft card. Now, there was a federal law that made it a criminal act to destroy one's draft card. So this scenario happened during the Vietnam War. And you've probably heard of the Vietnam War. Some of you may have served in the Vietnam War. So this individual, O'Brien, he was opposed to the mandatory military draft. He was opposed to the Vietnam War. He did not want to carry that draft card. And so in public, he burned his draft card. He burned his draft card in public. So the question for you, is that pure speech where government has to meet a very high test? Is that pure conduct outside the reach of the First Amendment? Or is that something in the middle? Okay, you can pause if you want to think about that, but let me go on to the scenario number 2. So scenario number 2 is during a political campaign. A protest was taking place outside the Republican National Convention, and many were out there protesting. They were opposed to the policies of the administration, opposed to the policies of the Republican Party. So as the protest was going on, people were trampling flowers, they had signs and what have you. They were outside the building. But one man, his name was Johnson, one man in the midst of the protest, he took an American flag. He said some derogatory words about the flag, and then he burned the flag. Now, some people said they were offended, but no fights broke out. So what I want to ask you, my question is, his burning of the American flag, was that pure speech, fully protected by the Constitution? Was that pure conduct outside the reach of the First Amendment? Or was it something in the middle? Okay, one more. Scenario number 3. So, as you probably know, in Washington, D.C., at the National Mall, there are often various assemblies and various peaceful protests. As a matter of fact, in 1963, the Washington National Mall, all the way up to the Lincoln Memorial, was the site of the famous Dr. Martin Luther King's speech. So the Washington National Mall, there is a group, and this group wants to protest homelessness. So they don't want to just walk around with some signs. It's in the winter, it's extremely cold. What the group wants to do is they want to put up some tents, and they want to sleep at night on the Washington National Mall. And they know it will be cold, they know it will be difficult, but that protest is to call attention to the plight of homelessness, where many people have to spend the night outside in the bitter cold. So that's the protest they want to do. And they put in an application in order to have that protest. So my question is, they're wanting to protest by sleeping on the Washington Mall in tents in the winter. Is that pure speech that ought to be fully protected by the Constitution? Are they requesting to do pure conduct? Pure conduct is outside the reach of the First Amendment? Or is it something in the middle? Now, in the text, in the bottom of the video, in the box with the text, I've typed out my read of the analysis, my read of the court's opinions in terms of what questions we should ask in determining how much protection ought to be given where you have a combination of speech and conduct. Now, speech and non-speech, some people call it symbolic speech. Some people call it expressive conduct. It's all the same thing, just different terminology. I want to say I've typed out the approach that I recommend to my students for them to take in and analyzing these problems, but I also want you to know the court has many cases interpreting the First Amendment, right? The explanations that I am giving you are my own, and they're not to be ascribed to my school or to my students. For informational purposes, I'm a professor of law at Mississippi College School of Law, and I've been teaching now for about 30 years in law schools and business schools. Now, this approach, I've sort of summarized it out of two different cases or several cases in terms of what I see as a legitimate approach to take in analyzing these questions. So here is the framework, and I'm just going to go through it, but it's typed in the text box. The first thing that you do where you have speech and conduct combined, you ask if there were an intent, if there was an intent to convey a particularized message, and if likely those who viewed it would understand the message. So when he burned the draft card, was there an intent to convey a message? And would those watching it or viewing it understand the message? Now, if the answer is yes, then likely it is not pure conduct outside the reach, right? If there was intent to convey a message, and likely those viewing it would understand the message that was being conveyed. So if the answer is yes, it is not pure conduct, and we continue on in the analysis. So if yes, we're dealing with symbolic speech or expressive conduct or speech and non-speech elements. So then we ask another question. We say, what are the government's interests in restricting the speech or expressive conduct or what have you? What are the government's interests? So we list the interests. And the draft card burning, the government would say, we gotta have a system. Your draft card will suggest what your ranking is in terms of your number coming up for you to be required to go into the military. We have to have an order. We have to have system. That's what the government could argue. We were not stopping all of your protesting, but you needed your card. You needed to have it on your person. Now, this is the point where the government could also talk about other interests. If the symbolic speech fell in an unprotected category, for example, what if when he burned the card, what if a huge fight broke out or there was an imminent threat of a huge fight from his advocacy? Then the government would say, yeah, we had an interest in maintaining peace, and his speech was fighting words. So even if it was speech, it was fighting words, and we had a rational basis. Are you seeing how all this pulls together? I hope so. Okay, now let's go to the next point. So we look at what are the interests the government articulates. Then we say, are there any interests other than the suppression of speech? In other words, we're testing the government's interests. Is all the government doing, is it just expressing disdain for your message? I mean, then there's a problem. But if government says we have some other interests, we're not just about silencing the speaker, then we proceed on. So if all of the interests are related to suppressing the speech, then we're going to require strict scrutiny, go to the higher level. But if government has some other interests, like I would say speech content neutral interests, then we evaluate under the middle. We use a middle test, and it's called the O'Brien test after the O'Brien case, which was about the draft card, and we'll talk about more in a minute. So what is this O'Brien test? Well, we ask if the government interests are unrelated to the suppression of the speech. If government is concerned about something else, right, then we use the O'Brien test, which means government has to have the appropriate constitutional power. There must be an important or a substantial interest, and the restriction on speech, the incidental restriction on speech cannot be any more than what is essential or necessary. It has to be incidental. Now, let's go back. That's the test. I may have bumbled that last part a bit, but it's all typed out in the text below this video. So let's go back to the scenarios. The public destruction of the draft card. Did you get that one right? What did the court hold? The court said that it was symbolic speech. He intended to convey a message, and that message could be reasonably understood. But they said, wait a minute, government has some other interests in terms of the Vietnam conflict or war, in terms of the system of selective registration, and those interests are unrelated to speech. He could have still protested the war, but not by destroying his card. And so in that situation, that he was under what's called the O'Brien test. The name of the case is O'Brien, which means government gets more leeway than here, and he could be punished for the destruction of his draft card. Okay? I think you probably got that one right, didn't you? Let's go to the next one. The next one, people feel very strongly about the American flag. Some people feel very strongly about protecting and respecting the flag. And some people feel very strongly about protecting the rights of speech. So in terms of the scenario where Johnson, the name of this case was Texas versus Johnson, in this case where he burned the American flag, what did the court hold? Let's go through the analysis. So the court said it's a combination of speech and conduct, but that Johnson had intended a message about the policies that he disagreed with. And it was a message that people understood when they saw him burning the American flag. So therefore, the court said it's not pure conduct outside the reach. It is expressive conduct or symbolic speech. So they go on to the next step. In the next step, the court said, what are the governmental interests? Why would the government want to punish this individual for burning the American flag? The court said, well, fight broke out. the court said he was not advocating illegal action. The court said the interests that the government state relate to the symbolism of the flag, the sacred nature of the flag, and what the flag means. The court said that all of those interests are related to promoting one message and silencing another message. So therefore, the court said, O'Brien test won't work for you. In order to punish someone for this speech, the court said, we're going to place this speech over in this highest category because the interests, government's interests, are all related to suppressing speech. So now government would have to satisfy a compelling governmental interest, and that their punishment of him for burning the flag is narrowly tailored to an interest. And the court said it was not satisfied there. Now, there was a lot of pushback about this opinion. Some individuals started an initiative to have a constitutional amendment added that said that flag burning was not protected speech, but that didn't go anywhere, didn't succeed. Then some members of Congress, they did pass a law called the Flag Protection Act or something like that. But when the court considered that law, the court said, no, you're still contrary to the holding of the court. The court said flag burning was protected speech, okay? But the court analyzed it under the higher category, the higher test, because everything the government said, all of their interests were connected to suppressing one message about the flag so that a message about the flag being sacred could be paramount. What do you think about that? Do you think the court got that one right? There was a dissenting opinion. So regardless of your view, you have some of the Supreme Court justices on your side. Now let's go to the last hypothetical about they wanted to have a protest on the Washington Mall, the National Mall. And as a part of the protest, they wanted to spend the night in tents in the bitter winter in the park on the mall in order to bring attention to the plight of homelessness. So there was a rule that said that you could not stay overnight in the park. So the court said, you can protest homelessness. Yes, they said that if we allowed you to sleep in the park, it's speech and it's conduct. It's not pure conduct because you have a message. And the court said, we believe your message would be understood. But then the court started to examine the interests of government. And it said that government does not allow anyone to spend the night in that park. It's a national park. There are reasons related to safety and cleanliness and what have you as to why they do not allow anyone to spend the night. So the court said that this is a content neutral. It's not that the government is opposed to your message, according to the court. It is that the government has other interests. So therefore, that are not related to your speech. The court said that it would be analyzed under that middle test in the middle, which gives more leeway to government. And therefore, you will have to protest in some other way. You're protesting by sleeping in the park in the winter is not required under the First Amendment, that government's interests were substantial and important, and you would just have to protest in some other way. So we see these three cases, and we see how the court analyzes this. Is it pure speech at the highest, or is it pure conduct? Is it something in the middle? If it's in the middle, then what are the interests of government? Is government just trying to silence the message, or does government have some other concerns? Where we evaluate the speech determines how much government has to show. Where we evaluate the speech determines the likelihood, somewhat the likelihood, as to whether the speech would be protected. So figuring out where it falls, pure speech, pure conduct, unprotected speech, somewhere in the middle, making that determination can have you well on your way in analyzing how the court will resolve the issue and whether the court will protect the expressive conduct or symbolic speech or speech and non-speech, whichever term you choose to use. And you're going, wow. Yes, the First Amendment is a short amendment, but it's fascinating, and there are so many issues and sub-issues. I've given the names of the cases below. You go and read them for yourself. Read the dissenting opinions too. You may find yourself more in line with the dissent, the disagreement from the majority in some of these cases. Look, my goal here is for my students and for all of us to take a soak in the law. A soak in the law. Learning can lead us on our path to enlightenment, and enlightenment to freedom, and freedom to justice, or at least to a taste of justice. Okay, thank you so much. Bye-bye.